there has to be some common sense.
Yes, sir. They have the car stopped at 10th and Ranch by Collider.
We still don't know who pulled the trigger. Hello, everyone, and welcome to Police Off the Cuff Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. And with me today is a treat because, during the day, most of the time he's teaching at Albertus Magnus College in Connecticut. And here we have with us today retired NYPD Sergeant, Professor, Law Degree, Mike Geary. How you doing today, Mike?
Doing well, Billy. Thank you for having me on.
Well, it's great to have you. There's some, I hate to say there's brand new stuff in the Bryan Kohberger case, but there is some new things that we should be concerned with, of course. And probably the biggest thing is the upcoming deposition with Brittany Funk. And, we've given our opinions. People, talking heads on the media, have given their opinions. And when the private investigator, I think his last name was Batandi,
yes,
who claims this is going to be like exculpatory information. I think that is a little bit of a stretch when they say exculpatory, information that tends to clear the defendant or tends to show the defendant's innocence. And what they may really be trying to do is, in the words of Bobby Chacon on Law and Order, we'll play it a little bit later, is they want to dirty up this witness. And what does that mean, dirty up a witness? And I'm going to let you respond to that, Mike.
Yeah, Billy, they're trying to look Bethany Funk. They know that, all of the students, all four students, and Bethany and Dylan were all, drinking, and they were out partying very, very late. And they weren't really aware of what was going on, probably, in terms of they're living separate, three separate floors of the house. And they probably have very inconsistent memories. And that's something to be expected. If many people could see a car accident, a homicide, some sort of crime take place, and they're in different areas. One's across the street, one's on a third floor roof looking down. They're going to have very different views and very different interpretations of what happened. So what they're trying to do, I believe, at this point, looking at what we know of the evidence, is that they're probably trying to show that there is some inconsistency between what DM and what Bethany Funk say, and what have said to the investigators, and what the police department and the forensic team and the crime scene people and the coroner's office have said is the timeline of the deaths. And if that is so, that there's an inconsistency, so what? That's fine, because people's memories are affected by, sleep, where they are, their perception. And I think what they want to do is just get her on the stand and just keep, hammering up. There's 4 or 5 or 6 things that she said that are slightly different than what Dylan, the other one, said, and what law enforcement believes. They just want to dirty her up a little bit by getting to the point, and that they'll make a trial. Also, right here in the preliminary hearing in front of the judge, is that this witness is very unreliable in their recollections, and therefore when they get to the trial 6 months from now, they can say to the jury, at the end, Bethany Funk, it was very, very inconsistent, she's unreliable, basically, please really don't put too much stock in what she said. She's really not a reliable witness, and her testimony is probably really irrelevant to Bryan Kohberger's guilt or innocence. Just dirty her up by making people doubt the veracity of the accuracy of her statements.
Well, Mike, it's a funny thing, and I'm glad you brought it up so succinctly. One of the reasons that investigators interview people in great depth right after an incident occurred is because that should be, and in fact, I believe it is, the clearest memory you're going to have of what actually occurred. And as time goes on, your memory starts to fade and you start remembering things differently. Does that mean you're lying or not telling the truth? No. You could just start remembering it differently. And that's why law enforcement and investigators take great pains to lock in a statement. Let's get that statement and let's get it down on paper, and let's get the witness to sign it and to make sure it's clear. And if there's anything that they want to change, that they don't believe that that's exactly what happened, and that's why, you may go over it 5, 6, 7 times to get it correct. And as I said, that statement taken by skilled investigators should be the closest to the actual truth and to the recollection of a witness. And you also hit it right on the head when you said 5 people could see the same incident. And it's very important that after that incident, if they're going to be witnesses, the police separate those witnesses. Because if witnesses are allowed to talk to each other, the strongest personality is going to put their feelings as to what occurred. And you have to let each person be interviewed, of course, separately, and not become tainted by another witness. And let them recall it, and let the police and the investigators, the detectives, get it down on paper, what they saw. And again, that will be the closest to the truth. And I say closest because, again, people's memories, it can change what you actually remember. I mean, I defy anyone to say they have total recollection after 6 months or after a year. And therefore, hours after a incident is, again, the clearest recollection that a witness is going to have. Mike.
Yeah, excited utterances are considered the most accurate and earnest and forthcoming testimony that you can have. I talk about this in my evidence class when we discuss, and we do discuss situations where, like I said, a person's in, somebody's watching a car accident, somebody's watching something happen, and they're talking about it to the police, and we do a little play acting. And I even in one of my classes, I used to get mugged in front of everybody during the middle of a lecture, and then I would just get up. The person would run out the door. They'd run in, run out, mug me, run out the door, and then I'd continue on with class. And then later on, like 30 minutes later, right before class ends, I'd say, "Okay, everybody, how many people were there? What were they wearing? What did they say? Did they display any weapons?" And here's a group of students sitting 15 feet from me, and you'd be amazed at the variety of answers you get. So inconsistencies show an earnestness, and that is okay because the jury understands that. If you're a prosecutor or you're a judge and you hear every single witness to a crime or to some sort of incident say the exact same thing as if it was scripted, then you know something's wrong. When people say things that may be inconsistent, they're telling the truth. Those excited utterances are considered the most earnest kind of testimony you have, because it is without planning, without guile. It's just something that somebody spontaneously says, and that's considered fresh. It's considered accurate. However, later on, of course, when they are interviewed by the police and they're starting to go over it, and they start to think about it, they close their eyes, they start to relive it. They'll maybe change what they time and things like that, and references what they may have said to someone after the first initial excitement calmed down. That's all normal, and the idea that the inconsistencies would be considered exculpatory, that's a real stretch, but it's coming from an investigator for the defense. And as we always see consciousness of guilt, they see exculpatory evidence, looking at the exact same set of facts. So there's nothing to worry about in terms of the evidence, how strong the evidence is against Bryan Kohberger. This is they're doing their job. The defense attorneys are doing their job. They're zealously advocating for Bryan Kohberger. That's their canon of ethics. That's what they have to do. I would do the same thing if I was them, and I would classify everything too as exculpatory, even if it's just inconsistent. That's all.
Well, Mike, one of the things also that psychologists have recently done studies on, and psychologists claim that eyewitness identification is unreliable.
Yeah.
To the point that they've convinced most police departments and I'm not going to get into this because it's a whole other topic,
Right.
to do something called double blind lineups.
Mhm.
And because psychologists have claimed that police personnel more or less steer the identification of the guilty person. Oh, well, I shouldn't say the guilty person, of the defendant that's in the lineup. So in essence, I really don't know, with police facilities being what they are, how they can actually do a lineup where it's possible for the police not to know who the defendant is. Because if the defendant walks out of the precinct after being arrested, someone in the police department is getting suspended. So for them not to know who the defendant is in the case is very risky, very dangerous. I don't know exactly how they do it, but according to psychologists, identification, the procedure of identification and eyewitness identification is unreliable. And, to tag that into something else, that's why video is so, so unbelievably important, because video sometimes identifies the perpetrator for us. And, but lineups, show ups, a show up, folks, for those that don't know, and we love to teach here every once in a while. If there's a crime on the street, say there's a stick up, and the police have the victim in the car with them, and they do what's called a canvas for the perpetrator. And if they spot the perpetrator on the street and the victim says, "That's him," and the police arrest him, that's a good identification. That's called a show up. It's a one-on-one display of the suspect to the victim. Now, the police can't be like, "Hey, is that the guy?" Because that's, of course, prejudicial. However, the courts, because of the time, or not a lot of time that's expired between the incident and apprehending the perpetrator, the courts have allowed show-ups. Now, a lineup, Micah, you can explain that. It's a totally different thing. Tell them what a lineup is.
Yeah, lineup. You can do like a photo array kind of lineup with the suspect's picture along with 5 other pictures, or you could do that in person. Lineup, the traditional one you see on TV, from movies, where you have 5 fillers, 5 men or 5 women, depending on the gender of the suspect, and you should have them all against the wall with numbers. They should be of fairly similar height, weight, build, hair color, if you can, that sort of thing. As best you can, try not to suggest who the person is, who the suspect. The police
Mike,
have.
just a little aside, something funny.
Yeah.
One time we had a defendant who was like 6'8", and we were
Oh,
like,
geez.
"How the hell are we going to get fillers that are anywhere near his height?" So we just made it clear we can't have them stand up.
Yeah,
They
just
gotta
sit them
sit
down.
because in the lineup paperwork that a defense attorney will read, it gives the height and the weight of the defendant and the fillers. So a 6'8" stick-up guy with a gun, how are you going to get fillers for that? And very difficult. So we had to use regular height people and just not have them stand up. And there's been times in lineups where I've actually, with a scripto pen, painted a mustache on people. And it actually worked. It looked pretty good, because you're looking through the two-way glass.
Right.
And it actually looked like a real mustache. I should have went to Hollywood with my makeup skills. But so that's the difference in a show up and a lineup. And Mike also alluded to a photo array. That's a photo lineup, and that's another way that victims will identify a perpetrator. They'll go into a precinct, and the detective will put in the criteria of the person who, say, robbed them. What did the guy look like? Okay, he was a male Hispanic. He was 5'7". He was about 150 pounds. He was muscular. What clothes he was wearing. I'll put that criteria into a computer database, and it'll come up sometimes with 400 or 500 photos of a defendant that fits that identification. And then what happens if the person picks out the perpetrator? That's not the end of it. The detective has to do certain checks, because many times a victim will pick out a perpetrator who's incarcerated upstate or on Rikers Island.
Right.
And that means that that person could not have done the lineup. So then it was a bad identification. So that happens all the time. And the other thing is in some respect, agreeing with the psychologist, is that if someone looks at hundreds of photos, basically their brain turns to mush, and they probably will never identify this person, at least in a photo array. Maybe in a physical lineup, it'd be a possibility. Mike?
Yeah, the photos tend to flatten everything out because they're not three-dimensional, and it's better to see someone in person. I remember once in the 4-6, we had a guy who he was very heavy set, and we had a picture of him, and nobody could pick him out and the detectives suspected him of committing a number of crimes, but he had lost about 150 pounds. And when they got him the next time, you look at this old photograph of him and you look at this new picture of him, and I remember putting the picture up right next to his face. And Pete, the detective, said, I could never pick that person out because his face was now slim. You could see his cheekbones. He had no double chin. And, he just looked totally different. And so it's hard from a picture. People, that's why I, as maybe suggestive as, on the scene kind of quick show ups, like right on the street. I think they're the most reliable because they are the ones that happen quickly, and you're seeing the person while their image is fresh in their mind. So from the defendant, the victim's point of view, I think that's the best. But pictures are very difficult, and lineups, that's difficult too, because you have to fill them in. What happens if the victim is looking at a lineup and the perp had like reddish hair? How many people are you going to get in a lineup that have that kind of hair? Somebody has brown hair, black hair, that's easy to get fillers. And then you're getting cops to have to be fillers. So cops might all be clean shaven, and then you have a perp who the suspect is, who may have a goatee, mustache, beard, things like that. It makes it very difficult. I like the on-scene type of thing, because when you're hunting for somebody, you grab a person. If you grab the wrong person, a person that's actually innocent, you want them to be identified quickly. And if they're innocent, you want to let them go so you can continue on, canvassing the area for the perp. So,
Mike, and also an eyewitness identification, that's not where the investigation stops.
No.
You'll also find out, if the person has an alibi, where was this person prior? Could that person have done that that robbery in the time frame that we know that it occurred? Or were they somewhere else? Check video. If they say, I was in this location at that time, and if the person's telling the truth, you can find that out. So detectives do as much investigation trying to prove someone's guilt as they do if someone is in fact innocent. They don't want to arrest this person. It could be a false identification, and we in law enforcement understand that. And we don't want to. Believe me, we don't want to put anyone in jail or in prison that didn't commit the crime. At least all the detectives I ever worked with didn't.
Yeah, I mean, because the consequences are so catastrophic. There's a very famous book. I can't think of the author's name. Picking Cotton. It's about a gentleman who was accused of, tried, and convicted of rape, and the person who ultimately found out that he was innocent, but the person who actually committed the rape could have looked like his twin brother. It was just remarkable. And you could see why the traumatized woman who was raped that night when it happened, got it wrong. But she was being totally earnest. And until you saw them in court together, you couldn't believe that they were so similarly looking, because there is a lot hanging on this identification. If it's robbery, it's one thing. If it's a homicide, it's a totally different thing. So cops never, ever want to lock up someone who actually is factually innocent.
No way. Law and Crime did a very good presentation today on the hearing and the interview with Bethany Funk. And I'm going to play a little bit of that. And I just want to say, one of the very best talking heads on TV is retired FBI agent Bobby Chacon, a real cop, 100% cop. A lot of these talking heads, believe me, that's all they are talking heads. Bobby Chacon is a 100% cop. His father and his brother were both NYPD sergeants. I guess that prejudices me a little bit, but he worked in Brooklyn with a homicide task force with the NYPD. So I can't say enough good things about him. So he's in this little Law and Order piece.
Witnesses, the state's witnesses, maybe even present their own evidence. So it's really interesting. So as we wait for all that, there have now been some recent developments that I want to get into. And that brings me right now to retired FBI agent and attorney, Bobby Chacon. Bobby, so good to see you. Friend of the program. Haven't seen you on Sidebar in quite some time. So it's good to have you back.
It's good to be back, Jesse. Thanks a lot.
Yeah, so let's start with the major development. The major development regarding Bethany Funk. Bethany Funk was one of the 2 surviving roommates in that house. She was in the house when the killings happened in the early morning hours of November 13th. Now, Kohberger's defense originally subpoenaed her to appear at the preliminary hearing, but then both sides agreed to quash that subpoena because Funk has agreed to be interviewed by the defense in Reno, Nevada, where she lives. Now, the question is, why do they want to speak with her? Well, according to an affidavit that was filed by the defense's criminal investigator, Richard Batanti, wrote, quote, Bethany Funk has information material to the charges against Mr. Kohberger. She was interviewed by police on several occasions. She disclosed things she heard and things she saw. Portions of information Ms. Funk has is exculpatory to the defendant. Ms. Funk's information is unique to her experiences and cannot be provided by another witness. Wow. Okay, so Bobby, as we know, exculpatory means information that would show Bryan Kohberger's innocent. What do you make of that?
Well, yes, it does. That's exactly what exculpatory means. However, the interpretation of whether a piece of testimony is exculpatory or not is very open to interpretation. And so while the investigator says she has things or stuff that is exculpatory to Bryan Kohberger, that's their interpretation of that, whatever that be. So arguably, in a case like this, in this case in particular, she is probably the most important witness. She's the only living eyewitness, if you want to call her an eyewitness, to the crimes that happened. So she.
Well, also we have Dylan Mortensen, who's the other surviving roommate. She's the one who allegedly saw the killer. So it's, that's a whole separate issue.
Both of these people in the house are really the only 2 eyewitnesses, so to speak. And so the defense is going to want to get into them as much as they can. They want to, what we call dirty them up if they can at trial, and anything that they can get to before trial helps them. So any statement, as part of the discovery process, that the defense gets all of the statements that this witness has made to the police, in any way. And so they've reviewed those statements now, and they want to talk more at length about those things to this witness before cross-examination, because I've had it where in my own statements where defense litigators will get into the littlest detail that you give and try to make you give an inconsistent statement prior to trial so they can.
Mike, I want to comment on that because one of the things I think we have to realize, and our listeners realize, is that this is a deposition. It's not the trial. So is this a Hail Mary pass to try, as Bobby Chacon says, dirty up this witness? Why are they doing this in a deposition? There hasn't even been the probable cause hearings yet. This is not the trial. Why are they? You think the judge, based on what she could possibly say, the judge will say, "Oh, we're not going to have a trial. There's no probable cause." I can't see that happening. So, explain to me why this is happening.
Well, usually depositions are in civil trials. You don't really see them in criminal trials, but I imagine because everybody is kind of spread out a little bit from Idaho and they're in different states. The judge is trying to be, as fair minded as she can be regarding the treatment of Bryan Kohberger. Everybody knows, exactly. There's a lot of evidence, scientific evidence and, electronic evidence, but they're trying to be fair. And this is what they're going to do is to say, okay, look, you have what you believe is exculpatory evidence. Now, exculpatory might mean just that you've seen some evidence or some testimony from Bethany that is inconsistent with Dylan Mortensen or someone else, and that's fine. And they may have identified her as the weaker, and I don't mean this, no disrespect to Ms. Funk, maybe the weaker of the two in terms of their consistencies between the time they talked to police originally and the time they made an official statement. Maybe they feel that her statement is a little bit more, they could punch some holes in it a little bit more than they could punch holes in Dylan Mortensen's testimony. So they may figure that she's the weakest. Get her in a deposition. It's sworn testimony, so that she will be she'll have to swear it's the truth. She'll have to swear to the accuracy of the statements, and she'll give another version of what she remembers. Obviously, at this point, months have gone by. She'll probably give a testimony that will be consistent with what she said originally, and somewhat inconsistent, because how you ask a question helps determine how the person answers. So they're going to go after her to see if they could just make her seem less reliable. And then later on at trial, maybe the prosecution might say, let's not put Bethany Funk on. She really appeared to be too unreliable. Or they might say, Bethany did great in the deposition. We've got to make sure we're going to put her on. And same thing with Dylan Mortensen, because you always want to have your own witnesses who are the most consistent and the most reliable. So it's the judge's, I think, way to try to even things out a little bit, give the defense its fair share of opportunities to get some of their statements before they actually go to the preliminary hearing and months before they go to trial. It will help the results, whatever they are, good or bad, for Ms. Funk. That'll help the prosecution, because then the prosecution will be able to decide also whether or not they want to rearrange a potential witness lineup for the trial.
Mike, someone asked in the chat that she'll be represented by an attorney at the deposition. Absolutely. I don't think any attorney would, for the prosecution, would let defense beat her up unprotected by an attorney for the prosecution. I mean, that wouldn't be fair, because what do we have, a 20-year-old, 21-year-old girl who's never testified, as far as I know, has never testified before in court or in an adversarial type of interview. And the prosecution would not allow her or these defense attorneys to go in there and just beat her up with no protection whatsoever.
Yeah, she's going to have an attorney sitting right next to her during the deposition. And if they'll probably ask what we call, direct questions, which generally are open-ended, which allow a witness to actually explain things. And that's perfectly fine on direct examination. How things might get testy with a defense team is if they start asking, leading questions, which are, cross-examination questions, which really are statements which suggest the answer. Like, you didn't have your glasses on, did you? You were drunk that night, weren't you? There's no way to explain. It's just very accusatorial. It's very acrimonious. And she'll need an attorney to say, hold on, counselor, we object to that question, that sort of thing. And that's a good thing, because if she testifies at trial, if she testifies at preliminary hearing, she's going to be exposed to that sort of thing. And she'll always have an attorney, either her own private attorney at this particular deposition, or at the trial, she'll have the state's attorney, the district attorney, to intercede on her behalf to make sure that the defense follows the proper conduct in court.
Mike, one of the things also, we watched some of the testimony, even in the Alec Murdaugh case, by some of the police personnel, and it's just some witnesses that may not have been trained well in the art of testifying, which there is. And especially at a deposition, the witness should give very, very, very brief answers. Maybe one word if possible, yes or no, but not run at the mouth, because that's when a skilled defense attorney can rip you to shreds. So you give the shortest answers possible, and you answer the question in the shortest possible sentences you can, because as I said, when you extrapolate, you get destroyed. That's for sure.
Yeah, I remember testifying my first trial, and the district attorney was saying, during trial prep, going over all the old arrest reports. I was with Augie then, and and he always reminded, don't, if I ask you a question, answer the question. You don't have to explain. And then on cross-examination, he told me, look, the defense is going to go after you, obviously, and just do the best you can. Yes or no. Don't try to explain. If I want you to explain, I'll ask you to explain. And I never had any formal training. I always felt very nervous testifying, because you're under pressure. There's a jury there sitting there. I mean, even if you went over all of the evidence, in a couple of days before the trial, make sure you remembered all those little things. Testifying in front of a jury, when you feel nervous, and then you have a prosecutor who's allowing you to just explain, was there a 911 call? What did you know? What did you see? What did you do? Why did you make the arrest? That sort of thing. And then and I think Bobby Chacon picked up on this, every little tidbit of information that may be somewhat equivocal, the defense is going to jump all over you. Why did you use this word rather than that word? And it's just like, and then you're like trying to explain, and you're not allowed to explain on cross-examination because you're getting leading questions. I remember one time asking the judge, my very first trial, I looked at the judge, I said, Your Honor, I need to explain the answer. And he smiled at me and he said, Officer Geary, just answer yes or no.
Yeah, it's sort of, in a way, an unfair advantage given to the defense. But then again, the prosecution has many things that are in there on their side of the court. Be real. Question is, why would the state not have done something to prevent this, or is the defense just trying to make something out of nothing, struggling? You be real. You explained it pretty well. I can understand what you were trying to ask. And Professor Mike, I'm going to let you answer that. Yeah,
this whole thing with this with the deposition before the preliminary hearing, it's basic due process, basic fairness. The judge is trying to be basically fair as much as they can to Bryan Kohberger. And at the preliminary hearing in June, I think we got about another 6 weeks to go before we get the preliminary hearing. The judge is going to be very careful to make sure that Kohberger's defense team, gets a fair run at the witnesses. Now, there's not going to be a lot of witnesses. There might be 6 or 7 witnesses, maybe, who knows? They're going to be testifying a lot, I believe, on the electronic evidence and on the blood evidence, the DNA evidence, and some crime scene photographs. And so there's not going to be 30 witnesses at this sort of thing. There's going to be a number of them. And the defense has every single right to cross-examine them, and they'll go hard at them. They'll take a fair run at them. And that's what we want in our criminal justice. And we want the prosecutor to, if you're charging someone with murder, you better have the goods. And this is the one time pre-trial that the defense attorneys get a chance to get in their court, get those prosecution witnesses under oath, and go after them, because cross-examination, we believe in our system of law, is the best insurer of truthful testimony, because you got the evidence being preferred by one side and it's going to be contested by the other. And we let the jury, which is considered the trier of fact, to determine what they think is accurate, what they think is reliable, and that's a good thing. So that's why it's this to-do. It's not the biggest to-do in the world, but it's very important for the defense to have this opportunity.
Absolutely. Folks, if you like real crime stories from a police perspective, then you're in the right place. Police Off the Cuff Real Crime Stories. We cover the real crime and the biggest stories of the day from a police perspective, all right? From myself, 27 years, Mike Geary, 21 years, Phil Grimaldi, 21 years, and our new frequent guest, Melanie Little, a retired attorney. We try to give it to you from our perspective, and not just our perspective, but for example, Melanie Little has not been in law enforcement, but she is a fantastic attorney. So it's given different perspectives on what we see. And if you're not subscribed, please go on our YouTube, hit that subscribe button, give us a thumbs up, make comments. We love to read your comments, and we love to respond to your comments. In addition, we have a Patreon if you want to support us financially with 3 different levels. And we have a YouTube channel membership with, count them, 5 different levels, and you can support us that way. So Police Off the Cuff, Real Crime Stories. You know, Mike, I'm going to play a little bit more of the Law and Crime interview. And again, I really enjoy Mike Chacon, who's
He's great.
he's a real cop, you know, which not all federal agents are.
Bring that out at trial as an inconsistent statement and maybe look like your memory is bad or you're lying or you really don't know what you're talking about. That's particularly important in cases of like height. I've seen it done in height where the person says, the witness will say the guy was about 5'8". And then the police say, well, could he have been 5'8" or 5'10"? And the person says, well, yeah, he could have been 5'8", 5'9", 5'10" in that area. And then the defense says, well, if he could have been 5'8" or 5'10", could he have been 6 foot or 6'1"? And now you've got somebody from 5'8" to 6'1", and they dirty up a witness that way. And then the witness's recollection looks really unreliable. And so in this case, I think what they want to do is they want to get into some of the details of what they told police and try to create seemingly inconsistencies.
Exculpatory is kind of that big word. I mean, it makes you say, basically saying, oh, we can definitively prove that he didn't do it. You know, there's another suspect. We don't know. I mean, exculpatory is the word that they chose. We know that her camp, when they were fighting the subpoena, basically said, quote, that this is without support. There's no further information or detail. And they're basically kind of, you know, watering down what information she has. But here's what we do know. Here's what we do know, Bobby, that she and this other roommate, Dylan Mortensen, were inside that residence at the time of the killings, that they were roommates to the victims. We believe that Miss Funk was in the first floor bedroom. According to the probable cause affidavit that, you know, came out when they ultimately arrested Bryan Kohberger, according to Funk, she saw Ethan Chapin and Zana Kernodle at a fraternity house from approximately 9 p.m. on November 12th to 1:45 a.m. on November 13th. She also estimated that at approximately 1:45, both Chapin and Kernodle returned to the residence. She also stated that Chapin didn't live in the King Road residence, which we know he was a guest of Kernodle. And she also said, or was also said in this probable cause affidavit, that Funk and Mortensen both told police that the other occupants of the home returned back November 13th at around 2 a.m. and that they were asleep or at least in their rooms by approximately 4 a.m. But there's one other thing. In the probable cause affidavit, apparently police reviewed forensic downloads from Funk's phone and determined that the homicides occurred between 4 a.m. and 4:25 a.m. So that's important information about the timeline. Remember, according to this criminal investigator, that whatever information Funk has, it's unique to her. Is there anything about that, the fact that she's so instrumental in putting the timeline, that the defense is trying to chip away at? Because if they can say the killings didn't happen at these times or her timeline's wrong, that may help Bryan Kohberger.
Sure, it may help him, but it's hard to see how that can be exculpatory. In other words, you know, unless they're prepared to prove that Bryan Kohberger was somewhere else at that time, if they can say, oh, well, it must have happened between here and here, but we have proof that Bryan was over here at that time, that can conceivably be exculpatory. But oftentimes a defense will say something like, well, this proves that there might have been somebody else in the house or something like that. And that's not necessarily exculpatory. You know, if there was somebody else involved in the crime, that's not necessarily exculpatory to this defendant. They might be able to, they might be trying to say that, you know, you have video of his Elantra in a certain place at a certain time. And if the crimes happened here, how could he have been in that house when his Elantra is on video over here at that time? So they're trying to, you know, play with the timeline, and they may think they have something like that where, you know, if you're saying this is him in this Elantra, which we're going to say it is, well, then the times don't match because the Elantra's on video over here. And now I don't agree that that's what the timeline shows, but that may be the line that they're going down.
You know, very interesting, Mike, that if I was the prosecution, I would not allow at all for Brittany Funk to be beat up at this hearing. I would just not allow it. I would be objecting every 2 seconds because, again, she's a very important witness. And when you have a private investigator using the word exculpatory, which when you have a great FBI agent like Bobby Chacon, who also has a law degree, by the way, all you guys get these law degrees on your way towards Oz, I guess, no easy thing to do, especially when you're working, when you're a working FBI agent or work. I think actually Bobby Chacon got his before he went on the FBI, but I know a lot of people, probably yourself included, got their law degrees while they were on the police department, which is it's nearly impossible. I don't know how you guys do it. It's unbelievable, and kudos to you.
Lots of coffee.
Lots of coffee and lots of basically all you can really do while you're in law school is answer phones because you can't be out on patrol.
Oh, it's terrible.
You just can't do that. Anyway, as I said, in this hearing, this deposition, she is an important witness. And, one of the biggest things, and this, Mike, from being a police officer as well as an attorney, what defense attorneys try to do is they try to dirty you up with a timeline. And I'm using Bobby Chacon's word, dirty you up. They try to lock you into times. And when he was talking about the time that apparently the murders happened, I think they have it down even to a narrower time frame than they just said. I think it's more like 4:15, between 4:15 and 4:20. They have it almost with the delivery of that food, certain electronic, and something. And thank God for electronic evidence. And every time I think of that New York Times article as the one who tried to impeach electronic evidence, I was like, oh my God, you're so wrong. You're a good writer, but you're so wrong about that. Electronic evidence is the smoking, if we can say something's a smoking gun. And I know a lot of people out there don't like that expression, but electronic evidence is such good evidence, so solid evidence. And because of that, they've been able to lock down this time frame to a much tighter, instead of way out here, it's much tighter. It's in here. So they can really, I don't know how defense attorneys can really, again, muddy someone up through arguing about the time frame.
Yeah, Billy, I mean, she's made at least several statements to the police, and maybe there was an inconsistency there, and that's fine. And if she's now going to do a deposition, she may say something that's a little bit inconsistent there too. And so going to trial, the defense is going to be like, okay, well, she's made a number of inconsistencies, so therefore, she really shouldn't be believed. If I'm the prosecution in this case, when it comes to the preliminary hearing, I'm going to get her up on the stand. Put her up there first. I'm only going to ask her several questions. What time did she get home? What time did she think? Did she think that, we're not sure, but what time did she think was her belief that Knodel and Chapin got there? And then get her off the stand so then you can get the electronics evidence in and the DNA evidence in. And then what I would do is I would only ask her just a few questions. And so then when it's time for the defense attorney to cross-examine her at this preliminary hearing, I would be very aggressive in limiting the cross-examination to only the points that I raised with her on direct examination. And I would insist with the judge that if I ask her just about the time and place that the four students got there at the house, and I got her on and off the stand in like 5 minutes, I'm going to insist that the defense attorneys do not go into any other territory other than rehash what I already opened up and admitted at trial. I'm sorry, I for the judge's consideration at the preliminary hearing. And I would go after that as hard as I possibly could. This way you protect her from all kinds of tangential attacks about everything else that might have been said. That's what I think. If I'm the prosecutor, that's what I want to do. Just a real narrow couple of minutes on the stand on direct, and then limit the defense attorneys from attacking her on anything just but what I said there. And I wouldn't go into anything further in terms of the timeline because I want to protect that witness. And we'll see what the judge says. The judge it's up to the judge to say, I'm going to limit cross-examination of the defense of the witness to only what was disclosed by the prosecutor on direct, or the judge might say it's a free-for-all. I doubt the judge will say it's a free-for-all. I think the judge will probably just say whatever the prosecutor has got the witness to testify to, those particular subjects, they're the only subjects that can be subject to cross-examination right here in this preliminary hearing. Remember, this isn't a trial. This is only the prosecutor's burden of proving, probable cause. That's all it is. And I don't think a judge is going to want to give free rein to any defense attorney to beat up a witness, especially a witness who's only talking about, one small thing. I don't think the judge is going to allow it. I think the judge is going to be fair to everybody and give the defense an opportunity to cross-examine her. But I think he's going to be very, very circumspect in what he or she what she allows the defense to attack.
How strong do you think of a witness, Dylan Mortensen and Brittany Funk, will be for the prosecution? In fact, I believe they will be prosecution witnesses and not, unless this hearing with Brittany Funk, this deposition, goes really bad for her. If it goes bad, then of course she'll be a witness for the defense. But if it goes well, I would think that she's going to be, Dylan Mortensen and Brittany Funk are going to be witnesses for the prosecution. I think it puts, Dylan Mortensen sees a male fitting the description of Bryan Kohberger. And, one of the things that's come out, that there could be many more physical descriptions. And when we talk about the physical description of someone, there's something called gait, not spelled G-A-T-E, but spelled G-A-I-T. And that's how a person moves, and that's their physicality. And look, when I was a kid, people would goof on the way I walked, and they said, it's not just you, it's your whole family walks the same way. It's like, it's sort of a funny thing, but it's true. People have a certain gait, a certain way they move. And, and I know in a courtroom, obviously, she's not going to say, oh, could Bryan Kohberger get up and walk? They would never allow that. But the physicality, and again, he had a mask on. He had apparently what was described as almost like a COVID mask.
Mm-hmm.
A lot of an identification also is in someone's eyes, if you can see their eyes. And I'm not saying it's a full-fledged, we're just discussing how tough it is to eyewitness identification. It's very tough. But that's it. I mean, I thought about, what if she could say, that's the same guy I saw that morning? What if she could say that? How powerful and again, it's woulda, shoulda, coulda. So maybe I shouldn't throw that out there. But if she could actually say, not that that's him, it looks like him, how powerful would that be for the jury?
Yeah, I mean, you would love to get, Dylan and Bethany up on the stand and say, as witness number one and witness number two, and then, have Bethany talk about the timeline, have Dylan talk about that's him, and go with that. Or the words like, I won't hurt you. I forget what the exact phrase was, that's his voice. But we talked about this a while ago, and, it's one thing to have her say slam dunk, that's the guy, those are his eyebrows, that's his voice. But you're rolling the dice, because you'd have to be willing to accept the fact that she may not be positive. I think the fact that you get them up on the stand and say he had bushy eyebrows and he was slim build, I think that would be good enough. Because remember, when he's at the trial, he's going to be wearing a shirt and tie and a suit jacket. So you might not be able to actually see this. He's not going to be wearing the same clothing as if he was wearing, something else. So you have to be really careful about that. Saying he looks like the guy based on his eyebrows, I think that's what we've already got, and it's already been testified to. It was already in the probable cause affidavit. I think that's as far as you want them to go, because you don't want to go any farther than that, because every time you take another couple of steps farther with a witness, and you then allow the defense attorney more area to then attack that witness on cross-examination. And I think get Bethany and Dylan up on the witness stand 1 and 2, get them to talk very briefly in a very limited manner, limited subject matter, get them off the stand. There's so much other evidence. The fact that they wouldn't be able to identify him in a lineup, I don't think that hurts the case whatsoever. I wouldn't want to take that chance. So I would just get them up there and get them off the stand as quick as possible.
Would a judge even allow a witness to say, yes, it looks like? I think a judge would, the defense would object, and the judge would probably sustain that objection.
Yeah, it's going to be probably up to the judge's discretion, because judges make hundreds of decisions, and unless they're absolutely erroneous under the law, their decision stands. And so, and remember, this is going to be in open court with the jury sitting right there. So if she says, well, he had bushy eyebrows, you're not going to have the prosecutor then say, well, look at the defendant's eyebrows. Are those the eyebrows that you saw?
Right.
Right. No way. It's not going to happen. Maybe in a movie you'll see that, but yeah, I don't think a judge would. The defense is going to, if the prosecutor said, does the defendant look like the man? And she says, kind of looks like him, or anything other than absolutely yes, I picked him out of a lineup. Other than that, I don't think a judge would have to worry about it. I think the defense attorney is going to jump all over, make a lot of hay. They're going to roast that witness. So I don't think the judge would even have to bother making a ruling on it, because it would just kill that witness's credibility. Remember, the prosecutors is playing chess with the defense attorney. They're making moves with their witnesses, trying to achieve certain goals and get certain information in front of the jury. But they also know that they have to block the defendant from saying certain things. So they are very careful in how they phrase their questions, the subject matter, the length of time they have this witness on the stand. So it's it wouldn't. I don't think it would hurt the prosecutor in prosecution's case in any way, shape, or form if neither of those two, Bethany or Dylan, say, point, the very dramatic thing in court. You've seen a movie, that's him. No, I don't think that hurts whatsoever.
Okay. Let's just listen a little bit more to Bobby Chacon here.
The fact that they want to interview her now, which I'm not even clear if it's a deposition, it doesn't appear, it may be just an interview, is the goal there. I think it's to see what information she has that may ultimately lead them toward another path. Whatever she says, okay, now we know where we can find additional evidence that maybe we want to show at a preliminary hearing. Maybe we don't need Bethany Funk anymore to testify at a preliminary hearing, but she can give us information and evidence that we can then present. You think that's what's going on here for that interview in Nevada?
Well, I think it's possible. It's also unusual. I mean, look, the defense usually gets all the statements from a witness, and then the first chance they get. I mean, depositions are generally the purview of a civil trial because most judges want civil trials to settle.
Even Law and Crime, Mike, has technical difficulties. So I thought they would have fixed that, but they didn't. They're much higher budget than us too, so they don't have that excuse. So just interesting, this whole deposition thing, interviewing a witness. Let's face it, the defense has the discovery. Another favorite lawyer's term: is the defense on a fishing expedition?
They have to be. They got to do everything they possibly can within the bounds of their oath of a canon of ethics to zealously advocate. They have to go on a fishing expedition. You got to put the bait in the water. You got to see. You got to throw the line out there, see what happens, because they've got their back to the wall. Every single bit of evidence has been in the possession of the prosecutors. It's been gone over with, FBI agents, technical people from, phone companies. You've got, fingerprint evidence, you've got bloodstain evidence, you've got all of the evidence. Just think about all the amount of evidence that they have. And so the defense is getting these things, but they're always on their back heel. The prosecutor and the prosecution is always, the state's evidence is always, they're walking forward. Defendants are always kind of like playing catch up. They're on their back heel. And so they have to try. And if I was them, I would do the same thing. I would look for the most minor inconsistency and say, Your Honor, this is unique, exculpatory. Please let us interview this witness beforehand. We need to, and then what they're trying to do is like Bobby Chacon says, see what she says. Does she really have anything else to offer? If she doesn't, we can negate her as an important witness. We can then, as defense side, we can then concentrate on, say, the obtaining, the processing, the safeguarding of the blood evidence or something like that. But yeah, this is absolutely a fishing expedition. They have to. They have to.
Well, DCPNW, no character assassination of these women witnesses. It's sad for them to be living your life one day and be thrown into the limelight with extreme pressure put on you the next. DCPNW, I agree. However, defense attorneys are going to do whatever the hell they want. The stakes here are potential death penalty. So they're not going to see it as you see it. They're going to see it as, we're going to give him the most vigorous defense possible. And if we have to, beat up a witness, we're going to do so. And any defense attorney worth their salt is going to feel that way. And they're not going to, we used to use the term, they're not going to care about ruffling someone's feathers. They're going to ruffle all the feathers they need to in order to do their job. So DC PNW, thank you for that comment. It was very much appreciated. And folks, thank all you guys for tuning in today. I know these early afternoon matinees sometimes take you guys off guard and take Mike Geary off guard, who's usually teaching at school. But, every once in a while he's around, and it's great. I was going to go on by myself and do a Coffee with Cannon episode, but I said, something? There is some relatively new information. I only like to use the term all the time, breaking news, because you always hear all of the TV stations say breaking news, and then they report on a story that we reported on 3 months ago. And I think that's a little bit dishonest, I think you should say. And but this is interesting, this hearing, this deposition, whatever you want to call it. And last night, myself, Melanie Little, and Phil Grimaldi, it wasn't even last night, we had another matinee yesterday. We spoke about the gag order in this case and the potentiality that it could be potentially, well, a small chance though, reversed, because let's not forget, the hearing begins June 26th, the probable cause hearing. So the next gag order hearing is not till May 25th. So I believe the judge, the gag order to be released, the judge would have to get right on that and release the gag order. I don't see it happening. So, I believe in a way it could be all academic after June 26th, once they have these probable cause hearings. And then people, the press, the families of the victims, and of course, the general public is going to hear a lot more about this case than we know at this time. Mike?
Yeah, I think this is one of the things about this case is because it's got so much publicity, it's a good learning tool for a lot of the members of the public who, have not worked in law enforcement or who don't have really experience in any way, shape, or form with law enforcement, because it does allow the public to gain more education and insight into actually what does a criminal trial look like? What does an investigation look like? And it gives the public tremendous insight as to what goes on. So I would implore people to read as much as you possibly can about the case, tune in to any of the broadcasts, and don't listen to the talking head stuff, but use it as a learning tool, because this is a case that will go from start to finish. And with so much publicity, there'll be so much analysis that the viewer will gain tremendous insight into the criminal justice system.
100%. And something, in a way, and even myself, I catch myself doing that. We have a sort of a diminished view of defense attorneys. However, if you ever need a defense attorney at some point in your life, you get in trouble, you'll have a new respect for the work they do, the job they do, because they're not all the same. There's really great ones and there's not so great ones, and there's some in the middle of the road and some at the lower level. But when you really have a great defense attorney, of course, and you say it's the best money you can buy, but in this case, of course, Bryan Kohberger is getting defense attorneys that are highly experienced, and some that have worked death penalty cases before. I just want to do this short commercial. Joe Murray, attorney at law. If you need a criminal defense attorney in the New York metropolitan area, then Joe Murray is your man. He's a retired NYPD member of the service. He retired as a police officer, and he went back and banged out a law degree, not just a law degree, an undergraduate degree before he got his law degree. And Joe is now a fantastic attorney. You can reach Joe on his cell at 718-514-3855. Email him at joe@jmurray-law.com. And his website is jmurray-law.com. Not only is Joe a fantastic defense attorney, but he's a huge, huge supporter of this show, of Police Off the Cuff. And he's been supporting us for, I believe, over 2 years now. And I always want to thank Joe. So, Mike, I think we did a pretty good job, if I may say myself, uncovering this relatively new information. Certainly not busting out and breaking news, but interesting information. And it's always good to get the perspective of an attorney, professor, attorney, retired NYPD sergeant. And again, I want to thank you for coming on the show today, because you have no life and you're available at a phone call away.
No, you're welcome, Billy. I enjoy this very, very much.
Yeah, it's and folks, this case is really such a huge, huge case, and there's so much emotion behind this case. And even when we read the chat and we field some of the anger that we get to people, which is fine. We've had anger directed at us when we were police officers. And some people get really mad that they say, sometimes they'll say that, oh, you guys already have him convicted. No, we don't. I'll repeat it again. He's innocent until proven guilty. But, we see all the evidence that the prosecution has and how the defense, and we like to discuss it. And again, you're entitled, freedom of speech, you're entitled, as long as you don't go over the top and get nasty with us, we'll listen and comment on your comments. Mike, final words.
Yeah, be patient and please pay attention. Everyone, please pay attention to the probable cause hearing and learn from it. And I think people will probably feel a lot better off about the evidence against Bryan Kohberger. They'll be much more sure of his guilt or innocence, however they feel. And so I think that's a good thing. So please stay tuned.
Folks, thank you for tuning in today. Have a great day. God bless from Police Off the Cuff.
Take care, everybody.
One episode just ain't enough.